I'm going to put my glasses on so that I can see. Mr. Dorenson, Mr. Goldstein, and Mr. Levine, if you would take seats here at the front table. Mr. Correa, welcome aboard. You know what? I think. I'm sorry. I meant that one there.
Oh, sure.
Yeah. Just. I'm going to welcome my colleague, Senator Correa, and we're going to get going. Everybody who's interested can either listen or watch on television or participate. I want to take a moment of personal privilege before we get going too far. At our hearing last week, the last time I saw a dear friend of mine, Jim Tabilio. I don't know how many of you knew Jim. I've been kind of sort of involved with him now in this issue of poker for the better part of a year and a half. Jim passed of a heart attack last Wednesday night, shortly after we adjourned this hearing. I will miss Jim. Traveled with him, attended a number of conferences with him, learned a lot from him. He had certainly been an instrumental part of this movement in California, and I would like to just take a moment of personal privilege of silence to recognize the work of my friend Jim Tabilio, who passed away last Wednesday. Thank you. For people who this may be their first time here, we're discussing the different elements of internet poker. We're discussing poker, gaming, the whole idea of whether or not the state can and should pursue revenue from online sources. Some of this came about from the passage of federal legislation. We're looking at different pieces and different styles of legislation here in Sacramento to try to capture this revenue. I made a decision that we would try to break the issue into, rather than try to capture the whole thing, because we found that we were discussing issues at cross purposes. So at some points we were talking about how do you do this or how do you do that. So we've broken it into kind of policy areas. Those of you who were here the first time, the discussion was about sovereignty and whether or not internet gaming would in and of itself interfere, conflict with the sovereignty relative to the compacts. The idea in this is an informational hearing, so we're not voting and we're not trying to specifically resolve it here, but we wanted to tackle an issue at a time. We postponed what was going to be our second hearing that was going to deal with the games that could be played. We combined that, as you may recall, last week with both the games that could be played and the number of hubs that we should have. The topic for today is the technical, financial, and legal qualifications for eligibility. So, again, the only thing that I ask is people try to keep the discussion to the topic because, I mean, for example, we've kind of done some of the other issues, and we've still got another hearing or so yet that we're going to be involved with. I appreciate, we've had good attendance. I didn't know so many people were concerned about internet gaming until we started doing this. Let me welcome my colleagues who are on the panel and certainly open it up to any of them who may want to make a comment. My colleague who was here earlier, Senator Correa from the great county of Orange. If you want to make an opening comment, or you don't have to, but you certainly can, sir.
Thank you, Mr. Chairman. I'll take that opportunity to, first of all, thank you for having this set of hearings. This can be a complicated issue, but if we break it down into pieces, I think we begin to understand and appreciate the complexities a little bit more. Again, thank you for holding these hearings. Look forward to adding my own thoughts on this issue as the committee progresses.
Okay, thank you. From the great county of San Francisco, my colleague Leland Yee.
Thank you very much, Mr. Chairman. My particular interest in this is that I would dare say that probably half of the individuals that are gambling in the state of California are part of my family. I have a particular interest in protecting their interests. But with that said, I would also say that I've been watching and monitoring the hearings from afar, and as you are drawing to a close these hearings, I thought I'd spend a little bit more time face-to-face listening and interacting, and so I welcome again these opportunities. So thank you very, very much.
Thank you. You know, we'll get right into it. We've got three experts on this panel. We'll have another discussion after this one. I want to move into it. I want to try to finish this in about 35 minutes, give or take. But we don't have a stopwatch, so we'll kind of sort of monitor. So at the point you become redundant, we'll kind of do something like that. But let me welcome Patrick. And if I mispronounce your name, it's only because I'm dyslexic and I went to one of those inner city high schools. Patrick Dorinson, did I pronounce it right?
Yes, Senator.
Patrick Dorinson is Executive Director of Poker Voters of America. It's on. You don't. As we would say in my neighborhood, sir, you've got the mic. Give us your comments.
Thank you, Senator. Mr. Chairman and members of the committee, thank you for inviting me to speak on behalf of Poker Voters of America and the United States Online Gaming Association about Internet poker. I'll be brief since we believe there are already in place the pieces to establish a legalized, regulated, revenue-producing Internet poker system in California in a relatively short period of time once legislation is approved by the legislature. Those pieces are quite simple, actually, and you already have heard from them during this process. The first are the California gaming tribes and California's card rooms, who currently hold legal gaming licenses. From here on, I will refer to them as the licensees. You also heard last week from Malcolm Graham, CEO of PKR and Chairman of the United States Online Gaming Association, presenting the legal operators who have been highly successful and have the expertise to put this together as they have done in international markets. From here on, I will refer to them as legal operators. And quite simply, here's how it would work. The tribes and the card rooms provide the licenses, and the legal operators provide the expertise. The legal operators would be the vendors who can provide all the computer architecture, as well as back office functions and perhaps some startup money if that's an agreement reached with the licensee. But whatever business arrangement a licensee and a legal operator agree to would be no different than, say, a contract to a firm to manage a casino or operate a card room. The legal operators would not now or in the future become licensees. That is not their desire. We believe, therefore, that eligibility to participate should be based on the following. The California Internet Poker System, should it be established, should be limited to current licensees, California tribes, and California card rooms. Only legal international operators that have not taken American bets since the Unlawful Internet Gaming Enforcement Act, or UGA, was passed by Congress in 2006 are eligible. We would recommend no Nevada gaming interests. California needs to protect its market share. To protect the state's investment, we would suggest an RFQ process should be established to set high standards and minimum requirements for participations, such as financial ability to participate, gaming experience, and integrity. The current licensees who are granted licensing for Internet poker will ensure, in concert with their legal operator, that any cost that the state might bear to establish a legal, regulated Internet poker system will be paid for as a condition of licensing, In these times, any internet poker system should be revenue neutral. The state should not have to spend money to put it forward. We're also open to the possibility of having an advance payment to the state's general fund, in addition to paying for Gambling Control Commission's startup costs. All business operations and physical operations must be located in the state of California. Now, I've been told by Malcolm Graham of PKR, whom you heard from last week, that once a regulatory framework is established, we could have a system up and running and putting money in the state's coffers, establishing a new industry, and creating an estimated 3,000 high-skill, high-paid jobs within 60 to 90 days. Malcolm and the U.S. Online Gaming Association, which I represent, have offered to lend their extensive regulatory expertise to the state to help speed the process along. If we work hard and act soon, we can be the first in the nation to establish a legal internet poker system. Let me close by saying I know we can get this done. Jim worked very hard on this issue, and I was a close friend of Jim's. We have been at this process since the first study bill was introduced by then Assemblyman Lloyd Levine over 2 years ago. Senator Wright and members of this committee have worked very hard to move this process forward. And as I said earlier, the pieces to get it done are before you. All we have to do is put them together. Poker voters and U.S. Online Gaming are ready to work with all parties to get this done. But we need to act. Every day that goes by without a legal internet poker system means that money, California's money and Californians' money, is going to illegal operators, and nothing for the state. Thank you, Mr. Chairman.
Thank you. Don't leave. We'll have questions in a moment. And I'm going to, Mr. Goldstein.
Thank you so much, Mr. Chair.
Welcome aboard.
Thank you very much.
Mr. Goldstein is a law and with the Poker Players Alliance.
Exactly.
Okay.
Mr. Chairman and other members of the committee, thank you so much for your time. I was asked to give just 2 seconds of background about myself because I'm not known to you. I'm a lawyer in Washington, D.C. I do get to come to the great state of California with some regularity. I teach at Stanford Law School and also at Harvard Law School. And I'm here on behalf of the Poker Players Alliance, which is the big organization in the United States of people who play poker. There are more than 100,000 members in the state of California. We regard California as essentially our home. And while the PPA had a speaker at your last session, I was asked to talk about this question of eligibility. Who's going to provide the services? In talking about that, I do want to just make sure that your constituents, the constituents of the other members who are here and who are listening in and have staff members paying attention, appreciate the leadership that's going on because, as my colleague said, California is at the cutting edge of this question. It's at the cutting edge of protecting its citizens through regulation of online poker. It's at the cutting edge of making sure that the tax revenue comes to the state of California to provide services that are needed for its citizens, and I hope that your constituents all appreciate that. I also hope that everyone understands that there is considerably more common ground than what divides us when it comes to proposals about having who's going to provide the services. Are we excluding we can cut to the chase here. It's about whether we're going to exclude as potential providers those entities that are providing services in the United States. My colleague suggested that the answer should be no. Other people believe the answer is yes. The difficulty is that kind of disagreement can prevent a solution to this problem because there's so many moneyed vested interests on both sides. There are licensed entities in the state of California that are well known to California regulators, that are trusted, that are great tribes of enormous history in the state of California that deserve to participate and are going to have a seat at the table. There are other providers, other card rooms, well-known institutions. I think we're going to hear from Bay 101, which has a fair amount of my money that it's collected over the years. And it too has tremendous respect. The question is, are we going to let the disagreement over the offshore operators and whether they're going to participate in this process and whether their services are going to be available to the residents of the state of California essentially derail the process? And so the point that I'm here to make to you is on behalf of the players that we think there is a substantial reason for you not to exclude them, and there's a substantial risk to the legislation if you were to do that. What the players want is the following. It wants the protection that you're trying to give them through regulation. That's only a good thing. You're ensuring that they're getting services from sites of integrity. But they also want competition. They do not want monopolies. Monopolies have not worked in the United States. They haven't worked in the state of California. They don't work in other places elsewhere. There are a series of providers operating around the world, regulated by France and Italy and other European governments, that know what they're doing and operate. They're multi-billion-dollar corporations. There are hundreds of thousands of people in the state of California are going to play on them today. And that's where they're getting their services from right now. And on behalf of the players, we believe that there will be better services provided if you get competition involving the people who have provided the service for more than a decade. Now, at the same time, we realize that it can't be a one-way street. You can't allow some site from outside the United States to come in, and because it has so many players and so much experience and so much marketing, deprive a California operator of the opportunity to compete as well. And so on some level, the model that was just described to you, which is a collaborative one, you have licensees in the state of California and also offshore providers, if they were to work together rather than fighting, is one that potentially has a lot of promise. It has a lot of promise as a practical matter, but it also has a lot of promise as a legal matter. Because, and I think this is the principal reason I was asked to talk to you, adopting a rule that says either all or some non-California sites cannot participate in the market, it creates a very serious constitutional question under the Commerce Clause. The Dormant Commerce Clause of the Constitution says that Congress gets to regulate interstate commerce. The Supreme Court has said that means that one state can't discriminate against people who come from overseas or from another state. We can't have just California providers. Now, obviously, if somebody is providing a brick-and-mortar card room, they're going to have a presence in the state. But if you can't say to California's residents, you must buy books from your local bookstore, you can't buy from Amazon, because that's unconstitutional discrimination against interstate commerce. Now, can you make sure that everybody who provides services in the state of California is licensed? Yes. Can you make sure that they are providers of integrity? Absolutely. That they deserve to be licensed? No doubt about it. But you can't take a set of providers and just exclude them. My colleague used a phrase that in a court case would be an unfortunate one. That is, California has to protect its market share. That's kind of a constitutional no-no. California doesn't get to protect its market share against foreign competition. Now, if you were to have a court case where these offshore providers were deemed to have acted illegally, you could say, well, they're not suitable to provide services. But the facts on the ground are no foreign operator has been prosecuted for providing online services in the United States by either the federal government or the state government. There's this general notion that they're operating illegally, but there's actually no facts to back that up. And if you were to say, well, look, I'm just convinced that they're violating the Wire Act, you'd be creating a dilemma for your own law. If the idea is that the U.S. Department of Justice is right when it asserts, it's never tried to enforce this position, when it asserts that an online provider is violating the Wire Act, and if you were to say, I agree with that, therefore I want to exclude these overseas providers that are U.S.-facing right now, then you'd be saying the California's own proposed law would be illegal as well, because it would violate the Wire Act too. So the second part of the message that we bring to you is be aware of concerns about excluding the overseas operators and consider whether this is something that's going to be solved first in Washington to get rid of this problem about the Wire Act. The current legislative proposals in Washington give California the option to opt in or opt out. They say, here is a system, you can decide whether to participate in it. We get rid of the question of illegality under the Wire Act, and we give you a huge proportion of the tax revenues. So the two sets of concerns to conclude that the players have are get us competition, it's a good thing, regulate but don't exclude, and consider the question of the chicken and the egg. Is the federal government going to go first or instead the state of California?
Thank you very much. Don't leave.
Yes, sir.
We're going to keep moving here. Mr. Levine is the attorney at law for the San Manuel Band of Mission Indians. Is that correct?
That's correct.
Okay, I just want to make sure I don't get folks' titles incorrect. Sir, welcome aboard.
Thank you. And I am appearing on behalf of San Manuel. And as you know, San Manuel is a principal in COPA and supports SB 40. I was asked to address the specific question about eligibility. One of the places I think to begin is to note that there's nothing in SB 40 that excludes others from participating. It approaches the question about suitability and licensing from the standpoint of the system that we now have. And we have a system in place that's been part of the public policy of California for many years. We have licensed operators who are experienced in poker. We have tribes that are subject to, as you know, 2 and 3 times regulation because of both tribal gaming regulators, their interface with the federal Indian Gaming Regulatory Act and Commission, and in some instances with the California Gaming Commission. So we have licensed and recognized operators in California who have been consistently following the public policy of California when it comes to operating and administering poker games. And what SB 40 does is simply say, we've got poker now that's coming into the modern age. We're using some different implements, but it's still poker. And this is about poker, and it's about poker for Californians within the state of California. And accordingly, rather than excluding everyone, we still just have a requirement in SB 40 that the applicants be licensed poker establishments or tribes that are authorized to operate gaming on reservations located within California. No great sea change there, no exclusionary language, nothing of the sort. And so I think that that's one issue maybe that is more of a red herring than anything else. As far as the applicants themselves are concerned, all SB 40 requires is that they be card rooms or gaming establishments that are licensed in California and tribes that are engaged in gaming under law in California. They can form an entity, and the encouragement now under SB 40 is that they do combine into entities, but there is some discretion that's allowed to the Gaming Commission to issue those regulations and to consider, I suppose, whether there's a question of whether there should be one or more of those, and perhaps there's been some talk about even addressing that issue in the statute itself by amendment. But that's a different issue, and it's one, again, that goes to the policy within California about whether or not it makes the most sense from a policy standpoint to have one or more sites within California, particularly since California is going to benefit from this activity and is going to have to regulate it. And I dare say that if regulating existing poker games is a challenge, and it is, and I think the CGCC recognizes that, then there are additional challenges in internet poker, and certainly not terribly difficult, but certainly challenges that have to be addressed. And because of that, we may have a debate about what the best policy is in terms of the number of sites in California. That, I think, is something the legislature can take up, but it's not a question of necessarily excluding anyone. Beyond that, I think as the first commentator noted, I think we do have regulations in place. We have a system in place. We have standards in place for how the game of poker should be regulated, and we're well on our way with operators who are more than experienced in how to operate that game. So that's what SB 40 tends to do, is simply add the overlay of doing that on an intranet basis within the state of California and for California residents.
Okay. Thank you much. Questions from the panel? Let me welcome Senator Padilla from the great city of Los Angeles, the San Fernando Valley. Questions?
Mr. Chair, I have a question, but rather a comment, and that is, first of all, thank the panelists for being here today and sharing your perspectives. Mr. Goldstein, it was very interesting, your analysis of the violation of the Commerce Clause, and at the same time, it was interesting we're talking about entities that have been doing business in California are breaking the law. I like the chair's analysis from your last hearing, I think, where you mentioned that we shouldn't be rewarding individuals that have broken the law. And I think what SB 40 effectively tries to do is essentially say this is for Californians, and hopefully we won't have to directly address the issue of the Commerce Clause or have to address the fact that we don't want to reward lawbreakers, but essentially come up with a mechanism that essentially says this is going to be a business that's going to be run by Californians for Californians to create jobs in the state of California. And I think all of us can figure out a way to do it. Last year I ran with a bill giving Californians a 5% bid preference on contracts, where if 80% of the Californians of that company were employees of the state of California, you'd get that 5% bid preference. And lo and behold, as we worked through the bill, I found that most states have these kinds of bid preferences. So I think we can all get together and figure out a way to assure that the legislation that we finally put together is one that really benefits Californians, and whether it's direct or indirectly, again, it does not reward those that have essentially operated in California illegally. Thank you, Mr. Chair.
Thank you very much, Mr. Chair. There's a lot of discussion relative to the fine points of how do we proceed. What are the technical aspects? Do we in fact bring in players outside the country, or individuals who are involved in this gaming business outside of the country, and so on. But there's a fundamental public policy issue that underlies all of this, and that is, how if we open the door to internet gaming, how do we, as the people's representatives, assure people of California that what we will essentially approve will be, in fact, in the best interests of the people? How do we capture as much revenue for the people of California? And it's interesting that we've had a number of hearings and still the debate goes on as to whether or not, do we have a variety of hubs and let just the market kind of figure that out. And to some extent, there's some arguments as to why that might be the way to do it. But at the end of the day, we all need to still ask the question, even though the markets seem to suggest that this is the revenue that the people of California will get, is that in fact true? Is that in fact still the best number that we can get for the people of California? Because I've seen, the market, and the market sometimes plays some funny games, and at the end of the day, the people get the short end of it. And then the other model that is kind of out there is, well, let's limit the individuals who are involved in this particular experiment, and let's see whether or not, in fact, they can give us the best amount of dollars that may be available. The argument against that may be that, well, by just limiting, one or two entities in this particular arena, you may not get a representative sample, and therefore you may not, in fact, get the best dollar. It's still interesting to me that after all these hearings, we're still not yet settled on what that model is, and I think it's extremely important for me, because I gather that there are a number of vehicles, or there are a number of possibilities that are out there that we've got to get some clear data about that particular issue before we can kind of move forward. And so, Mr. Chairman, I just want to kind of make that observation, and I hope that after these hearings and as we proceed with dealing with some of these bills, that we get to some point where we will have objective data as to which model is going to generate the maximum dollars for people of California.
Mr. Chairman, if I could just offer very brief thoughts. I think I could say with confidence that all the members of the panel, though we have different proposals, believe that you've identified the critical concerns, and that is, are the people of the state of California being protected, and is the state getting the revenue it deserves? That is common ground. Also, Senator Correa, you said we want people who are not lawbreakers, and that has to be common ground as well. So let me give you my very quick reactions to both points. The question of whether a model that excludes the principal offshore sites will provide the greatest protection to the citizens of the state and the revenue to the state, the answer to that question is regrettably no. Those sites have so many players on them right now that if they do not come to the table in a regulated regime that excludes them, hundreds of thousands of people in the state of California will continue to play on the other sites that don't generate the regulatory regime that you want and don't generate the tax revenue. We need them to come to the table and to be a part of the process because there are hundreds of thousands of people playing in tournaments. These are sites that offer $1 million tournaments every week. If we don't give them an incentive to come be a part of our regime and be regulated, then they'll continue off wherever they are, and citizens of the state of California will continue to play there. We need them to be a part of the process. We need them to operate lawfully. We need them to be regulated. We need them to give us the tax revenue. But we can't hold them at arm's length. Then on the question, to Senator Correa's point, the difficulty is that none of these sites, while there is a view, and I understand it's sincerely held, and it is one that is based on significant legal arguments, these sites have never been prosecuted, have never been deemed to be violating California or federal law. And so I can just tell you, in court, they have an extremely strong argument that what you're doing is you're protecting in-state interests versus out-of-state interests. So that would be the legal issue that's created. You would avoid that legal conflict. You would bring the tax revenue here if instead you had a model that said, we're going to have the great tribes of the state of California, the great card rooms of the state of California, and these offshore operators are only going to be able to participate if they pair up, for example, with an existing licensee and they demonstrate their suitability for licensing. If we don't have that kind of regime, I think the tax revenue is going to stay offshore. You're not going to regulate them in the way you want to protect the citizens of California, and you're in for a significant legal fight.
Through the chair. You're right. A lot of this legislation, and I would imagine doesn't matter how we do it, is going to entail some litigation. So a lot of the clashes, the conflicts that you point out, legal conflicts, are really probably issues that are probably be decided by a judge or a jury. Either way. Yet again, I continue to think about if these guys have been working offshore with these huge pots of money, what is their incentive to come in and do it legally when they've been doing it illegally so far? I just don't see why you would come in and start, playing under the rules of the state of California and have to share some of your winnings, however it's structured, with California when you've been doing just fine now.
I could give you one quick answer.
Sure.
I apologize so much for interrupting. These sites, everywhere there is a regulatory regime, Italy, France, a whole bunch of European countries, every place that there is a regulatory regime, they apply for licenses. So to the question of what can we look at as an experience that shows us that the citizens will be protected, these sites, there is no regulatory regime in the United States in which they can participate in. Where there are regimes, they have submitted themselves to it. And there is, I think, a good bit of data about it, sir.
So an Italian operation operating in Italy has applied for a license to work or operate in Italy.
No, I apologize for the confusion. The sites, I think we could name the sites we're talking about. We don't have to say it in the abstract. The big sites that are offshore operators that have given significant concerns to my colleagues, places like Full Tilt Poker and Poker Stars. There is PokerStars.fr, PokerStars.it.
And they're operating out of?
In those countries under licensed regimes, yes,
From
sir.
those countries?
Yes, sir.
Is it part of the licensing requirement that they operate lawfully around the world or just in Italy?
They are subject to the same sort of suitability review that the California gaming regulators implement. They're examined very closely.
But my question is, would part of their licensing requirement and their country of situs is that they operate lawfully under all the laws of just Italy or other countries as well?
I don't know the answer to that question. I think they would be.
And my question is really going toward the issue is, you're already operating within Italy lawfully, but the Italian authorities know that they're operating unlawfully in the state of California. Is that an issue that bears any merit on you getting a license in the country of Italy?
I believe not, but remember...
So again, I would come back to my question. Sure. What's your incentive to operate legally within the state of California after we pass our, legislation versus today? I don't believe that there's any economic incentive to comply with the laws of the state of California.
Okay, that question I can answer, sir, and that is, there's regulation in Italy, there's regulation in France and a variety of other countries. There wasn't 2 or 3 years ago. So PokerStars and Full Tilt Poker would have been operating in those countries exactly like in California, where there wasn't a regulatory regime. Those countries created a regime, and then the sites submitted themselves to it. The sites don't fear regulation. They make plenty of money.
That's pretty clear.
That's pretty clear. And they are not hiding behind that fact. If they can be invited to participate at the table and submit themselves to regulation, experience, as I can point to each nation that has adopted these regulatory regimes, they actually have come to the table and participated.
Let me ask you just a side note to the chair. You mentioned that a lot of the players won competition, yet you just stated that a lot of the players are drawn because of the $1 million purses. It sounds to me like these players are really looking for action as opposed to competition.
Well, I think that they believe that competition will produce that. If you have a regulated regime with a lot of sites that are available, more players will come and participate. Competition just produces bigger prizes, lower rakes, better services. They do want sites...
I think the way you get to bigger prizes is you have more action in a place where you're playing. If you have just a few players, I don't see how it would be economically feasible for you to give out a multi-million-dollar winning.
Well, I guess we have to distinguish between competition and the fact that there have to be 20 sites. I take your point to be a really valid point of economics, and that is, if you take 100 players and you divide them between 20 sites, there'd only be 5 at each one, and there wouldn't be action. There wouldn't be a big prize. Competition here doesn't mean there have to be 20 operators. Competition means there has to be competition. You have to let people come in and try and prove their best, try and prove that they can provide the best services. There might only be 3 or 4 in the end, but competition means you don't start by limiting the number of people who can compete. That's my only point.
Mr. Levine, a concern I would raise is, in one of our earlier discussions, we heard from the Lytton tribe. And the Lytton tribe doesn't have a compact, but they do play poker and they do run gaming businesses on their reservation.
Yes.
Would they be able to bid under your regime? They have no license other than the fact that the federal law allows them to play on their land.
Now, we're dealing with 2 separate issues. One is, can they play poker? And they can under federal law.
Right.
But those poker games are subject to regulation by the Tribal Gaming Commission. That must be part of a gaming ordinance and system that's been approved by the Federal Indian Gaming Commission.
But
so, and they are.
Let me go back and let me again.
Yeah, okay.
But Lytton doesn't have a license from the state of California. We don't license them because they can play poker on their tribal land without any approval from the state of California. So, and arguably, the poker games that take place on compacted tribes, the poker portion isn't licensed either. We only have regulation relative to the slot machines that they use. If there were no slot machines, there wouldn't be a compact. The compact only addresses the slot machine. So going back, technically, to the specific point, what would you do with a tribe like Lytton if they wanted to apply?
Well, I think in order to comply with SB 40, there is a requirement that they submit to the regulatory jurisdiction of the state. That's part of SB 40, and in exchange for that, of course, you get compliance with the federal law that limits internet poker to games that have been authorized by the state government. So there is a gap that has to be filled there, and that gap, I think, has been taken care of in SB 40.
The point I make, so you would then allow Lytton to apply for a permit?
I would allow Lytton and any other tribe that had gone through the eligibility.
No.
Yes.
Okay, but
the answer is yes.
Lytton currently has no license, so then would your limitation for applying for a license be to Indian tribes? Lytton has no license right now.
Well, they have a.
Not in California. They don't. They don't have any relationship to the state of California. They can, a tribe can right now set up and play poker on their tribal land without the permission of the state of California.
Well, except that they can't just play any game of poker. They can only offer poker to the extent that it's offered within the state of California.
I understand, but California authorizes that.
And complying with those rules is subject to the supervision and jurisdiction not only of a gaming commission that has had to pass muster with the federal gaming commission and chairman of the gaming commission itself, and the Secretary of the Interior, but also with that commission as well. SB 40 would go a step further because in order to engage in internet poker, even within the state of California, you would have to be able to submit to the regulatory regime of the state. So I guess I don't agree that they're not licensed in the sense that a license regulates, because they did have to apply to the federal government. They did have to get that permission. They did have to adopt an ordinance. Mm-hmm. They do have to submit to various kinds of regimes, and they also have to offer games that are consistent with the hours of operation and some other requirements under the Indian Gaming Regulatory Act.
But the federal government regulates them. We don't.
Well, they regulate. The federal government oversees their own regulation,
right.
as we know, which is a scheme, though, that has been recognized by the California legislature, obviously, because we have a lot of tribal regulation, even in Class 3 gaming, that's conducted pursuant to a compact. So,
right. But well, I mean, I won't belabor that because we'd go around, but the licenses and the discussion we were having about the tilt and stars. When we look at licensing here in California, there are a lot of restrictions that we place that speak to the character, not just whether or not the person had committed a crime.
Yes.
And the concern that we would have in both 40 and 45, we're not asserting that they committed a crime. We're just saying that it's poor character. And on the character issue is why we excluded them. It wasn't because we specified that they committed a crime. I mean, if you were running a brothel, which would be legal in Nevada, we might consider that unsavory and deny you a license in California. You didn't commit a crime in Nevada, but we consider it unsavory in California that you ran a brothel. It's not illegal in Nevada. The other concern that we found was that, to your point, both Stars and Tilt attempt to obey the law. And if, as in the state of Washington, it's been our experience that Tilt and Stars withdrew their business from those states at the point that that state adopted a law making the play illegal. And if either of our schemes goes through, our Justice Department advises us that you want to make it illegal specifically for the reason that you could go to the regulators in the countries where those sites operate and say to the regulators in those states, your companies are operating outside of California state law, notwithstanding what the federal government says. So both of these bills actually creates a crime in California, and it's been our experience both in France, Italy, and Sweden, which each attempted that. Sweden had a more difficult time because their regime didn't preclude people from advertising and doing some of the other things. One of the other concerns, certainly, that people would have here would be the liquidity that they would have. Those companies would have a burden to make sure that they didn't commingle the resources. So they would have to ensure that they didn't take the California player and mingle him with their international players. And the monitoring of that would be a grave concern, because that would be illegal pursuant to UEJA. You could not transfer the games to the other sites in that fashion. The issue of the Dormant Commerce Clause raises a significant concern. I mean, we are, ironically, we in California won recently a lawsuit on the Commerce Clause relative to wine shipments. And those states that allowed the importation of wine within the state but didn't allow California wines to be exported. And we were meritorious in that lawsuit about 4 or 5 years ago. But we will, again, we will continue to look, and it is a concern, again, as to how you do classifications and recognizing the Dormant Commerce Clause. My reading and what I've been told by our Ledge Council, and we will seek it again, is that preferences are often allowed, but outright bans get very close to violating the Commerce Clause, is what we were given as information. It could be wrong, but that's kind of where we stop. The question becomes, for example, and I'll leave it to you as this: you could place in a regime that the company has to submit itself to California regulation. The question is, do you allow people to submit to California regulation? Go ahead.
Well, that was one of the points I was trying to make, is that we're sort of rediscovering the wheel, because we already have a regime in California, and we have a public policy in California. Whether they're tribes or whether they're licensed card rooms, they are already following all of those policies that California has struggled with for many years. Right. And so to now suggest that, well, maybe we should look beyond the horizons of California and be concerned about unknown entities from somewhere else without imposing on them the same requirements that everyone else does.
But there's no discussion that, and there's no proposal that they would receive disparate treatment. Everyone would receive the exact same treatment. The question becomes, would we be able to say to the Lytton group, you don't have a license in California, therefore you can't apply to get one?
Well, if you're talking about tribes, our disagreement on that issue, I believe they are licensed and recognized.
You're just wrong.
The policy of California.
You're just wrong.
You mean that they're not authorized to conduct poker?
They're not licensed by the state of California.
They're not licensed by the state of California. I agree with that.
You specifically said licensed by California.
No,
they're licensed by the federal government.
If I said that,
relative to California, you're just wrong.
If I said licensed by California, I misspoke. I did not mean to say that.
You did, and you're wrong. So we'll move forward, okay. And we speak to California licenses in some of the legislation. So you're correct. You cannot. Well, anyway, we won't go around that.
Their activities are recognized in California as being compliant with the law. We have a public policy that is still in place, and that's what I was trying to emphasize.
Okay. Yes, sir.
Senator, I think you've made almost too many good points to count.
I get in trouble like that all the time.
You make the point that, look, the body of people who are going to apply for licenses is going to expand. Take the Lytton, in terms of a California state license. They are physically in the state of California. They're a great tribe. They're a sovereign nation, but they don't have a California license. Presumably, the tribes that support the bill want them to be able to apply. The question is, and so we're going to add some people to this regulatory regime. Where are we going to draw the line? And I believe, from the players' perspective, on behalf of the Poker Players Alliance, that you should draw the line in a way that brings everybody to the table rather than trying to keep somebody at arm's length. you do create a crime. I think a good, strong regulatory regime would be a good thing. And this helps answer Senator Correa's point. How will we know they'll comply? Because if California has a law in the books, like the state of Washington, then you can do exactly what you described. But the question is, all right, once you've got that leverage over them, once you've got them, what do you do with them? Do you try and keep them away? Or do you try and bring them to the table because they have a huge amount of experience? They have experience in closed environments with, for example, with France and Italy disagree about whether it's only the French and Italians can play. The Italians, it's just going to be Italy, like you would just want Californians. I believe they have something to contribute. I believe they have economics to contribute. And I don't believe that they want to come in and defeat through competition the licensed entities in the state of California that get so much respect. What they would end up doing, and what they're going to do in other states, if states go before the federal government, is pairing up in the way that my colleague suggested, although he would exclude those that face the United States right now. They would pair up with the tribes. They would pair up with the commerce. They would pair up with the Bay 101. You would have everybody in the regime. All the tax revenue would be in the regime. All the providers would be regulated. And you would get the suitability review that you talked about as being so essential. The last quick point that I'll make is that it's a very smart move. It will get a lot of attention, but I don't believe it will succeed to say we're not excluding them because we think they broke the law necessarily, because that hasn't been proven, but we regard them as being unsuitable because they are operating in the United States under very strong legal opinions that say they're operating lawfully. And I believe a court will say this really is an attempt to exclude out-of-state competition. I think that version of the bill buys a fight, asks for a fight that's totally unnecessary. People could come together here and everybody could win and the state of California could win.
Okay, let me take a moment. I was remiss and welcome Senator Ed Hernandez from the San Gabriel Valley in California, and the Vice Chair of the committee, Joel Anderson, from the great county of San Diego. Are there further questions that we have of this panel? Let me ask Jeffrey Sinheimer if he would come. You guys don't leave, because at the end what we do is take questions from the audience, and there may be questions of some of you. So if you don't mind, if you'll stay. Jeffrey, if you'll come forward and take a chair here. Jeffrey is an attorney at law for Bay 101 Casino in California.
San Jose.
San Jose, California.
Great county of
Santa Clara, as I recall. Formerly known as Speed City for people who were involved in track and field.
Oh, sorry. Mr. Chairman and members of the committee, at the outset, I would, with great sadness, like to align myself with the comments that the chair made at the beginning of this process with respect to the passing of Jim Tabilio, and recognize his loss not merely for this process, but for an incredibly active and thoughtful human being. We really appreciate being invited today to speak on these issues. I have certain things to add and certain things to amplify about what was talked about before. I represent Bay 101, which is a licensed card club in Santa Clara County in the city of San Jose. And we really are looking forward, in the words of the chair, that some consensus is going to be reached soon on this issue in order to establish a multi-hub competitive framework in the state of California so that we can participate in a current market for online gaming that takes $2 million a day out of California to offshore operators, and has the potential not only to provide alternative lines of business and alternative markets for our card club, but also, depending on the two published reports that have been presented to this point, and I think that this addresses something that Senator Yee raised, somewhere in the order of $1 to $6 billion over the next 9 or 10 years, depending upon whether or not you're looking at the report that specifically deals with the proposal for SB 40 or the proposal for SB 45. I would note with respect to those proposals, piggybacking immediately on what some of the colloquy that just took place, that one of those reports depends almost entirely on the rate of recapture of current players who are playing within California on offshore sites. It is not immediately apparent that the idea of including offshore sites that are taking bets currently in a manner that is inconsistent with the financial reform in UEJA is in fact a pro-competitive or an anti-competitive move. I think that that question is certainly a policy question for the committee and the body and the legislature to deal with. We do believe and agree with the previous speakers, the two previous speakers that have talked about the idea of granting preferences to existing Indian tribes, card clubs, and horse racing interests, not mentioned in the previous panel, that are currently providing gambling services within the state of California. We view both the license fee regulation enforcement model in SB 40 and the franchise revenue split contract compliance model, different model in SB 45, as works in progress. And so any references that we make to them today are not for the purpose of endorsing one or the other. Our goal today is to flush out some of the issues that have been raised in the previous panel about 3 different issues: financial, legal, and technical qualifications, in order to be able to maximize the benefit to the state of California, as well as to create a truly competitive market here and have as corollary benefits with respect to the deployment of broadband facilities, including clouds in the state of California, and increasing employment in the high-tech community, which is so vital as we go forward. So the questions that I'm going to deal with are twofold. First, what standards will be used to determine if an applicant for a hub is financially and technically qualified? Those issues, as we unfold them, don't necessarily have the strong Commerce Clause, Dormant Commerce Clause, Supremacy Clause, federal constitutional issues that are tied with them. And then second, examining the question of whether or not California can either limit the legal qualifications to specific pool of applicants or give preferences to applicants based upon their status as card clubs, tribes, or horse racing providers offering gaming or gambling in California, and otherwise excludes providers based upon whether or not they have taken actions contrary to federal law. Along the lines of the description that was previously made, I do agree. There is a Dormant Commerce Clause problem here. The Dormant Commerce Clause it says that essentially the power of Congress to regulate interstate commerce also implies a restriction on the ability of states to pass legislation that is overly burdensome on or discriminates against interstate commerce. That does not necessarily mean that all systems that have preferences are excluded from the mix. What it does mean is that where simple economic protectionism, in the words of the United States Supreme Court, is affected by state legislation, a virtual per se rule of invalidity has been erected. Now, that, again, I want to come back to the notion that that is an important element to consider when we get to the question of legal qualifications in order to be a hub. But we also have questions about financial and technical qualifications for hub eligibility that might in and of themselves be justified by the grant of Congress under the Unlawful Internet Gambling Enforcement Act. And at a minimum, I think that we need to consider those questions which are dealt with extensively in SB 45 and in SB 40. There are 10 that I outlined very quickly, and I'll go run through them as quickly as possible given the late hour. The notion is essentially that hub applicants will, in the words of Mr. Jorgensen, actually have teams of people that will come in and apply, not just as the licensee, but for many of the different specialty subsets that are involved in actually providing gaming services. I come from the world of broadband. I am, by training and by expertise, a cable lawyer. I came out of the broadband world, and so these notions of financial, technical, and legal qualifications are ones that basically revolve around the notion that in order to provide broadband service, one needs to be able to do a myriad of different things. But whether we're talking about, say, for example, telehealth in the purview of your committee, Senator Hernandez, or whether we're talking about online gaming, or whether we're talking about smart grid in the purview of Senator Padilla's committee, we are talking about essentially broadband applications that have a variety of different implications to them, each of which will be an element of whether or not or if, as a policy matter, people will be able to demonstrate to the body, in the case of SB 45 and SB 40, the Gaming Control Commission and the Bureau of Gambling Control, that they are in fact qualified. So what are these factors? The ability of the hub operator to succeed in its business plan and raise revenue. One projects that there would be, in addition to that, some form of bonding or otherwise bids in order to demonstrate that truly a hub applicant was in fact serious about putting in place the elements to actually do this kind of business, which is a competitive business under any and all circumstances with offshore providers, because we do not have the ability to block that kind of traffic from coming into the state of California, or for that matter, for it going out, even if we were to render such activities to be criminal in the eyes of the state. We need to give tax agencies the ability to collect winnings, taxes on winnings from players. These are database issues where a hub applicant is actually going to have to demonstrate that it has the ability to process financial applications in order to, in some sense, get 45% of the projected net revenues into the state through personal income taxes by complying with existing state personal income tax laws. We need to give control over what games are authorized. This was discussed at length in terms of what games, in fact, should be authorized. But the fact of the matter is that we're going to have people who are able to demonstrate to the Department of Justice and to the Gaming Control Commission that they have experience and that they can technically do those things. There are three aspects of player protection that I think that are important here. The first is that the results are random and that games are fair and free from fraud and collusion. There was a question that was raised last week, at the end of last week, by Mr. Wu in response to a comment from Senator Padilla that, in fact, we should be considering games that go perhaps beyond poker and up to the limits of where the Constitution actually places these things. Mr. Wu's question specifically was, well, how do we know how Zynga, which is an important provider of games, not gaming, in the state of California, recently valued at $15 billion and headquartered in the city and county of San Francisco, how do we know whether or not their games are fair? The reality is, if you look closely, particularly at SB 45 and what SB 45 says as a matter of technical qualification, a hub applicant has to demonstrate that it has either itself or as a member of teams the technical ability to ensure that the results of games are fair and free from fraud and collusion. This is an important technical element that involves all sorts of different aspects of computer data processing, algorithms, and a variety of different things that can be put in place today. And we know from Mr. Graham's testimony last week for the Online Gaming Association that there are at least 7 experienced firms worldwide which have not taken bets in the United States since the passage of UEJA, all of which are capable of doing that kind of data processing and would be eligible in the process for a hub license here in order to be able to put us in the best position to have the best kind of competitive process here in the state of California. We need to make sure that financial accounts are secure. The legislature has vast experience with data breach law and data notification law, but it needs hub applicants who are not only willing to comply with those laws, but embrace them here, since the potential for abuse is incredibly strong given the amount of financial data that is going to be running through this system. And the same thing is true of privacy and personalized data, which needs to be protected through the process. There are three other important aspects that are in the bill. One deals with protecting minors. As a technical issue, companies exist today, including companies headquartered here in California, that have the ability to ensure that players are over the age of 21 and therefore eligible to play under either Mr. Correa's system or the system proposed by Mr. Wright, or the system that we would think would be part of the consensual process here. As a policy matter, the executive director of Wired Safety has said that the best way to protect youth is, in fact, to legalize and regulate and present an alternative in the state of California by abstraction from her testimony in Washington, D.C., that, in fact, does those things. We need a process that basically ensures a computerized process from a data point of view that the games actually are truly intrastate. Because in order to comply with UEJA, the technical ability needs to be there from a data point of view. And we know that California companies, in fact, are providing such services to offshore providers who are providing services legally in places like Europe at a rate of 99.7%, according to their audit figures, in order to ensure that, in fact, not only is the process truly an interstate process in terms of what we are trying to achieve, or the legislature is trying to achieve, but also in terms of compliance with the federal law and UEJA as it exists today. Finally, we need a process for suitabilities, not only for the operators, but also for their employees and their contractors. And this, I would submit, is an area where the California-based companies, for the most part, who are regulated, have an advantage in terms of being able to speed to market. I submit that beyond that, there is no reason to discriminate against those providers in California, such as the Linton Tribe, who are operating here legally. But from my point of view, the really important thing that we need to think about is, okay, once you get to this point, what is the number of hubs? Again, much discussion last week, but the question remains that the truly competitive market is going to be a market where there are, in fact, multiple players. What we have learned in looking at New Jersey, which recently passed legislation in this area, is that they basically default on the area of technical and financial qualifications as UEJA being the justification for going down that road. So, for instance, internet wagering is defined as placing wagers with a casino licensed using a computer network through a casino licensee that may offer games to residents of the state. Interestingly enough, as both bills appear today, it is not dependent upon whether or not residents of the state are actually playing, but people are physically present in the state and playing, which is, I think, an improvement upon what we could learn from what took place in New Jersey. We also need to make sure that books and records are available. New Jersey does this in a very interesting way by requiring that those books and records be actually within New Jersey. So again, the harder questions are not on these areas with respect to financial and technical qualifications, whether or not somebody needs to post a bond or actually needs to make a bid that guarantees or somewhat demonstrates their desire and their commitment to being involved in a competitive market. But the question really is fourfold with respect to whether or not the state of California can, in fact, have forms of legislation which are pointed directly at the idea that players' needs are met by operations that are within the state. And the four areas that I've identified are, number one, whether or not you limit eligibility or you give preferences to entities that are providing gambling services within the state today. Number two, whether you actually exclude entities that are either violating federal internet gaming or banking laws or in other ways are acting in abject that are looking at UEJA as something that they can in fact ignore. Whether or not you are requiring whether hub facilities and the staff for those hub facilities must be within the state, because that too is a form of discrimination. And fourth, whether you require companies to in fact incorporate within the state, not merely those that are the licensees, but also the subcontractors. New Jersey, again, goes down the road of not really dealing with those questions specifically. And from our point of view, it seems to me that preferences are the best way to approach this. I'd like to close, though, by saying that there was a press report last week that actually says that state regulators have approved the first computer online gaming service in the state of California, which is dubbed iCasino and is being offered by the Blue Lake Rancheria. From our point of view, the question of eligibility is front and center, if for no other reason than the press report, whether or not true, implies, in fact, that within one casino at their gaming site, state regulators have, in fact, passed muster that an iPad application is, in fact, legal. This, from our point of view, is a very important step because it demonstrates that, to a certain extent, we are on a clock here. It is important to act quickly. While I'm not sure that the optimistic 3 to 6 month time frame is one, even with comprehensive legislation that can get you to the point where you're actually getting revenues, these revenues still continue to flow offshore at an alarming rate. And this means that the state is not, in fact, taking advantage of the opportunity to get into a market where, in fact, today it can provide some framework in order to be able to maximize the benefit of the state, to protect players, minors, and problem gainers, attract investment, increase deployment of broadband facilities, increase employment, respect the brick-and-mortar providers who are currently providing gambling services within the state, and yield revenues to the state by taking black market activity out of the shadows and making it legal. Thank you much, Mr. Chair, and I'm open to any questions.
Thank you. Any questions from the panel? Okay. Well, I don't have any. I thought you were kind of thorough. What we're going to do is quickly move. Are there questions from the audience to the panelists? You guys have done a good job, didn't it? Or you just scared the hell out of everybody? I'm not sure. Let me ask, sir, if you would let me have, why don't you take that microphone there, Mr. Collegian?
My name is Hank Collegian from Copa, Bicycle Casino, etc. I have one question for the gentleman from the Poker Players Alliance. I heard you state, and I want to make it clear, that even if a law is passed and we legalize internet gaming, that we won't get all the business because your illegal operators will continue to operate illegally. How can we accept that type of disrespect to our California laws when you, as an attorney, have stated that you're going to continue to do business anyway?
I don't think he said that.
Well, that's what I heard.
No. His specific comment, I'm going to speak for him, was that in the countries where games have taken place, that they've complied with the law. That was, I'm paraphrasing for you, but I remember Mr. Graham made that comment last week, and I thought you reflected that again, that they submitted themselves to the regime and they complied with the law in the countries where those laws had taken place. I know that was, from my own experience in the state of Washington, that they that they cease playing games in Washington after Washington passed a law to the contrary. Are there any other questions? If the members of the panel would summarize, what we're probably going to do is chronicle some of this, and if you've got additional comments that we can take on the subject that you have. It's not a requirement. Obviously, you guys are all, highly paid lawyers, so I can't, beg.
I'm not a lawyer, Mr. Senator.
Oh.
And I'm not highly paid.
I just got a land-grant university education.
Well, if there are some comments that we can take, that we want to, keep for the record, clearly, let's take the microphone right here. We're going to revisit the issue. We've had some discussions with our own Justice Department and our alleged counsel relative to the Dormant Commerce Clause. So it's not something that has gone, totally without discussion, and we will be refining that and getting more input over the next couple of weeks. Yes, sir.
Mr. Chairman and members, John Norwood on behalf of Churchill Downs. The committee did extend an invitation to our client to testify today, and because of travel arrangements couldn't get here. We hope to maybe get him here at a later date. But I thought I'd just make a couple comments on the Cliff Notes version maybe of where we might be. I think Churchill Downs and their 3 California subsidiaries would generally favor an open and competitive system for internet poker in California, and I think we would believe that the state could limit the number of participants by the financial, technical, reputational, and legal qualifications for firms to bid as hubs. I guess in our opinion, to do anything less would essentially have the state devalue the franchise, and I think that goes to Senator Lee's concern that the state make the best deal on behalf of its residents. There are some as testified that we should limit the qualifications to individuals that are currently licensed to offer poker in California, i.e. the tribes and card rooms, and certainly that is understandable, but internet poker is a 2-word description, and the other side of it is that internet gaming, the only legal internet gaming in California, is currently occupied by the horse racing industry, and our clients are advanced deposit wage license holders that provide internet gaming with the horse racing industry today, and we believe that if there are going to be preferences in the eligibility criteria for those to bid as hubs, that ought to include that aspect of gaming in California. With that, I would just hope that our client has an opportunity to expand on these issues, especially the financial and technical and legal issues at a later date. Thank you very much.
Thank you. Next week, we're going to have some folks from the Justice Department to talk about some of the regulatory aspects of how we would move the games. And strategically, again, some of the things that we'll be looking at, because there become 2 sources of revenue. One source of revenue becomes what you take on the front end, if anything at all, and the other would be what you take as a portion of how the game is played. Still kind of sort of sorting through, do you want to get yours now, or do you want to get it up front? And that would speak as well to the hub question, because there probably are, I think, as Mr. Graham said, there's probably 6 or 7. Having myself travel to Europe, it ain't like there's 50 people that are capable of coming into play. Even some of the larger internet companies here in California, most of them could have played or bid to play in European countries, and they haven't. So I know we were having discussions, for example, about Google. Google operates in Italy, France, and Sweden, and they've never attempted to play in any of those countries. I don't have any reason to believe that they would attempt to play here, given that they could have played there over the last 10 years and haven't. So that's, I don't know how much we need to try to ring fence, but the concern clearly becomes if we short shrift the game. To your comment, Mr. Norwood, are we cutting ourselves away from revenue that we'd otherwise be entitled to by limiting the pool of people who get to play? And on the other hand, what criteria and what recognition do we provide for people who've been operating and laboring in California for a long time? Let me thank all of the panelists. We try to let all of you have the last word before we run out, but we've gone to the audience. Any final words from any of you? There being none, let me thank everyone. Yes,
Mr.
sir.
Chair, if I may
say
a couple of words. First of all, I want to thank also the panelists, and I'm going to say your testimony really helped me go back and re-examine some of the issues as there's the way I addressed it in my legislation, and shed some additional light based on your testimony. I'll tell you, I'm particularly challenged by Mr. Goldstein, the challenge you posed to us of the Interstate Commerce Clause, and I just looked at it as a challenge because I think at the end of the day, we as California legislators can come up with a way to protect our taxpayers and our citizens from individuals that are operating outside the state unlawfully, whether it be through a preference or through some other method. But we'll go back and look at that as a challenge. Thank you very much, sir.
Thank you, sir.
That being, we're going to adjourn. Again, thank everyone for coming. We'll see you next Wednesday.